specific, what I would call the laundering or masking of delegitimization under universal public values. And my main thesis is that this is not simply a threat or prejudicial to Israel, though it is that. It is a threat and prejudicial to these universal public values. And here I'm referring to the protective cover of the United Nations, the authority of international law, the culture of human rights, the struggle against racism. And so when you mentioned, Rachel, that I come as an advocate of Israel, I come here today, and that has been the manner in which my advocacy for Israel has been anchored, with respect to the pursuit of international justice. I come to the support of Israel not simply because it's a Jewish cause. That would not be enough for me. I come to the support of Israel because I believe on the facts and on the law, with whatever imperfections there may be in its case. It is, at the end of the day, a just cause. And if it is a just cause, then it deserves the support of all men and women of goodwill in each of our countries. So let me deal today with 4 manifestations of the laundering of delegitimization under universal public values. For reasons of time, I will deal with only one example under each of these manifestations, though one could write a book about each one of them. The first is, as I mentioned, the laundering of delegitimization under the protective cover of the United Nations. Every year at the General Assembly, what has become an annual ritual that has been proceeding now itself for over 40 years. Every year, the United Nations General Assembly adopts some 20 resolutions of condemnation against one member state of the international community, which happens to be Israel, and only 4 resolutions against the rest of the world combined. Now, I'm not telling you anything that you don't know, but in legal terms, and in terms of international justice, what we are witnessing here is a standing denial of international due process, where one country is singled out for differential and discriminatory treatment, and the rest of the human rights violators enjoy exculpatory immunity. And when one looks at the resolutions that are adopted, they read, and not accidentally, they read like legal judgments, alleged findings of fact and conclusions of law. And they focus increasingly on the settlements, because those who drew up and draw these indictments know very well that America, Canada, Europe are legal cultures. If you say something is illegal, it's far worse than if you say it's stupid or ill-advised or wrong. And so you have a series of resolutions dressed up as legal judgments, increasingly focusing on the illegality of the settlements, with all the resonance that that would have in legal cultures in North America and Europe. But it doesn't end there. As someone who is a member of a Canadian delegation to the United Nations, in the course of the adoption of these resolutions, you have to appreciate that there's not only a critical mass of indictment in the singling out of one member state, but a critical mass of exposure to that indictment. Because these resolutions pass through a 3-month process. Almost every single day, somewhere, there is a meeting, a forum, a conference on the way to the indictment. And the delegations to the United Nations are made up not only of diplomats, they include parliamentarians, academicians, journalists, NGO reps, faith leaders, and the like. So there's a critical mass of exposure to the process that leads to the final indictment. And most of the members of these delegations, as I witnessed when I was there, don't necessarily come to the United Nations with any particular bias against Israel. Is that they come there uninformed about Israel, but they listen to and are exposed to this drumbeat of incitement for 3 months. And at the end of that, they internalize that drumbeat of incitement and then end up seeing Israel through the same optic of those resolutions which effectively brand Israel as a major lawbreaker in the international community. So that's the first manifestation of the laundering. The second is the laundering of delegitimization under the authority of international law. Now, you've heard about this, and I could speak to this, whether I would reference the International Court of Justice judgment, or the ICC, or universal jurisdiction. I want to take one particular example because it is so compelling in its outrageous selective discrimination and prejudicial impact. I'm referring to where the contracting parties to the Geneva Convention convene with respect to the Fourth Geneva Convention on the Law of Armed Conflict, exactly what you are speaking about in terms of the laws of war. And on December 17, 2014, the state parties to the Fourth Geneva Convention convened to put one state in the world in the docket. It was not Russia, it was not Syria, it was not Sudan, I can go on. The only state that was put in the docket for violations of the law of armed conflict was Israel. Now, this has happened 3 times in the last 50 years. Each time, the only state put in the docket was Israel. And so what you have here is a laundering of delegitimization under international law in general, under international humanitarian law in particular, but you can begin to see that the damage that is being done, the prejudice, is being done to the authority of international law itself. Which brings me to the third manifestation, and that is the laundering of delegitimization under the culture of human rights. And here I will take one case study, as I said I would under each manifestation. And here I'm referring to the United Nations Council on Human Rights, which is now commemorating its 10th anniversary as the repository for standard setting in international human rights and the successor to the UN Commission on Human Rights. Now, it's not only that some 50% of its resolutions single out one member state in the international community. Again, you know what that state is. It's not only that some 50% of its special sessions and emergency procedures, again, single out one state. It's not only that at every meeting of the UN Human Rights Council, every meeting, and I've been there and I've witnessed it, it begins with one agenda-specific item relating to Israel and an agenda item for the rest of the international community combined. So what you have at every meeting of the UN Human Rights Council is that one member state is singled out for indictment even before the hearing begins. And that's why, in a situation such as commissions of inquiry, whether it be the Goldstone Commission or whether it be Operation Protective Edge, if you look at the resolution establishing the Commission of Inquiry and taking Operation Protective Edge as a case study, there are 18 separate references to the alleged criminality of Israel. I say alleged, but the resolution reads as if it is a statement of fact and law. 18 separate references to Israeli criminality in the establishment of a commission of inquiry to look into the question of whether there has been any violations of the laws of war. And not one reference in that resolution establishing the commission of inquiry to Hamas. You know, an Alice in Wonderland situation in which the judgment is pronounced even before the hearing begins. And I faced this as well. In 2006, I was invited by the then UN Commissioner on Human Rights, Louise Arbour, who had been a colleague. We had taught together at Osgoode Hall Law School. She was a member of the Canadian Supreme Court, and then had become the UN Commissioner on Human Rights. And she called me up and said, Irwin, the United Nations Council on Human Rights will be establishing a commission of inquiry to looking into the killings of Palestinians in Bet Hanun in northern Gaza. Bishop Tutu will be one member of that commission, and we'd like you to be the second member. And I said, will this commission of inquiry be visiting Sderot? And she said, no, why would it go to Sderot? And I said, well, it's because rockets were being fired from Bet Hanun to Sderot on a systematic basis, that when Israelis responded to that rocket fire, regrettably, one artillery fire went astray and Palestinians were killed. She said, no, it won't be going to Sderot, but you'll be a member of that commission. You'll be able to speak to the issues. I said, Louise, I've read the resolution establishing the commission of inquiry that you're asking me to join. It says in its resolution establishing the commission that Israel willingly murdered 18 Palestinians in Bet Hanun. So what is there to investigate? You've already predetermined the outcome. I said, I'm sorry, I don't intend to be a fig leaf for the UN. I certainly don't intend to be a Jewish fig leaf for the UN. This brings me to my fourth manifestation, and this is the laundering of delegitimization and lawfare under the struggle against racism. Let's face it, one of the worst things you can say about anyone in the world today is to call them a racist. The very label supplies the indictment. And in the case of Israel, you don't only refer to Israel as a racist state, as was done in the Zionism as racism resolution, but now you refer to it as an apartheid state. But apartheid is defined in international law as a crime against humanity. Therefore, this calling of Israel an apartheid state is not happenstance. Because people know that if you refer to Israel as a crime against humanity, then if it is a crime against humanity, this state has really no right to be. And if that is not enough, then you call it a Nazi state. So not only does it have no right to be, but there is an obligation on the international community to ensure that it has no right to be. And in polls that were done with respect to taking some 8 European states as case study, some 40% of its citizens, when asked, do you believe that Israel is behaving towards the Palestinians the way the Nazis behaved towards the Jews? 40% answered yes. And so we see the cumulative impact of the laundering of delegitimization under the rubric of the struggle against racism. And so the question then becomes, what do we do about all this? And what do we do about this lawfare? For reasons of time, I'm going to make some suggestions or proposals. This is an informed audience. You don't need any elaboration from me. But my generic principle and proposal here is that we have to come out of the docket of the accused, where we are always framed as the criminal defendant, and become the plaintiff, become the claimant. Not only the plaintiff or claimant on behalf of Israel, but the plaintiff or claimant on behalf of these universal public values. In other words, become, if you will, a melitz yosher, a public advocate for the very universal public values that are themselves being denied or corrupted in this laundering of delegitimization. Because if we make the case, and this is my first point, if we make the case simply that delegitimization is prejudicial to Israel, then the answer will be, well, it should be prejudicial to Israel. Israel deserves to be delegitimized. It is a major human rights violator, etc., etc. And so the point has to be made here